Okay, good evening, everyone. Good evening, good evening, good evening. And we want to welcome one and all to another dynamic program sponsored by Malls NYC. And this evening, our program is a special one, very dear to my heart. And the reason that it is because of the fact that it's so much to know about protecting our idea and our dream. It's so sad. So many people have such a great idea, work so hard for it, and somewhere along the reason, either by force of nature that they have to sell or what have you, they just lose it all. And right now there is an increase, I should say, individuals are getting in their mailboxes on an increased level cease and desist letters. And that's the most painful thing any business owner could ever endure, where it's your business, it's your idea, you didn't take it from anybody else, but somebody realized that you didn't protect it and they had bigger pockets than you, grabbed it. And I know Tom, this is his area, he will talk about it. But when so many people coming to me complaining about this, I had to do something. And who else did I know that was a guru in this area but Tom? And he was willing, very busy man, but he was willing to share from his heart and his knowledge. And for the amount of questions that came before him, created a powerful presentation for us today. And for that reason, that's why we are here, to learn how we are going to protect our business valuable intellectual property. And so welcome one, welcome all. And now I'm going to read a little bit about our speaker, Tom O'Rourke. So Thomas O'Rourke is a founding partner of the firm Boder and O'Rourke. Mr. O'Rourke's practice involves all areas of patent, trademark, and copyright law. For over 30 years, he has been registered to practice before the United States Patent and Trademark Office. Mr. O'Rourke has counseled clients regarding the procurement and enforcement of patents, trademarks, copyrights, and trade secrets in a variety of technologies, including mechanical and computer technology. In addition, his practice involves domestic and international technology transfer, acquisition, and licensing. Mr. O'Rourke has been a member of the board of directors of the New York Intellectual Property Law Association. He has lectured on intellectual property law at numerous continuing legal education programs, including programs presented by the American Bar Association, the Connecticut Intellectual Property Law Association, and the Suffolk County Bar Association. He was also the editor of the New York Intellectual Property Law Association Bulletin and the author of numerous articles on patents, trademarks, and copyrights for the New York Intellectual Property Law Association. Mr. O'Rourke has also authored monthly articles on intellectual property law licensing, which have appeared in the Licensing Journal. Mr. O'Rourke has also been named as a super lawyer. Mr. O'Rourke has a BS degree in chemistry from Fordham University and obtained his JD degree from St. John's University School of Law, where he was a member of the Law Review. And so, ladies and gentlemen, I bring before you someone that is well decorated in knowledge, and he is none other than Thomas O'Rourke, Esquire. Tom, you're on, and I welcome you. I'm going to give you sharing rights here so you can share. This is the Malls team and family of business owners, and they're going to give you their undivided attention.
Nice to meet everyone.
Hi, Kyle.
You too.
Okay.
Do I have the screen?
Yes, you haven't shared yet. You've seen that little green button at the bottom that says share screen.
Let's see.
Uh, It's somewhere around, it's usually a green arrow sticking out somewhere around the perimeter at the top or bottom. If it's on a PC, it's
I
usually,
see it. No, that's meeting information.
and then when it opens up onto your desktop, it sees, once your presentation is already up, it will actually find it.
I see the share screen
Yeah,
and, okay,
there you go. We are seeing you now. There you go. So you just have to put it on from beginning, and I think we will be good from there.
okay, here we go.
Yeah.
All right. All right, so let's start off with some definitional terms here, because a lot of times people mischaracterize what their ideas are or what they're doing, and they're not sure whether it's a copyright, a patent, a trademark, a trade secret, whatever. So patents relate to inventions, and we're going to go through that in a lot of detail. Trademarks relate to names or slogans that are used for products or for a business. Copyrights are things that are more artistic in nature. For example, it could be photos, music, computer software, books, things like that. And trade secrets are ideas which people make a conscious decision not to go ahead and get a patent on, and they're going to keep it secret from everybody else, and that's what they will try to protect. Now, each of these items have certain benefits and certain risks that we're going to talk about. So this is my contact information. We'll skip over that. So right now, here's a patent. This is what you would get once you get a patent from the United States Patent and Trademark Office. So in the patent, there's going to be a detailed description of the invention. So you're going to have to describe, and this is where the attorney gets involved. You're going to have typically drawings, and you're going to have a lengthy description on what is in the drawings, how the invention works. You're going to talk about how different it is from the prior art. And basically, it's a document that's written to try to convince the examiner that your invention is something over and above what everybody else has developed before. So in order to get a patent, you have to be different from what's out there before, but it can't be an obvious difference. So for example, let's say you have an idea for a product, and right now they're made in metal or wood, and you decide, well, I think it'd be cheaper, let's make it in plastic. That would be an obvious difference, and the examiner is not going to give you a patent on that because it's too close to the prior art, and somebody skilled in the art would say, that's just a normal change. Similarly, if you would a product that was used in one business, let's say for people, and then you were making a similar product, but you were making it for pets, that's also typically an obvious change, and it's not easy to get a patent on something that is just a change of an old idea into a new use. But that being said, there are a lot of different things and a lot of different ways you can have an invention. All right. So let's talk about some inventions. Okay. So here we have a picture of probably one of our favorite inventions, because we wouldn't be here tonight without being able to use electricity and have lighting. And so we're talking about the electric light bulb. Now, a light bulb, there were light bulbs out there in the past before Edison came up with his bulb. Some of the problems that they had with the early light bulbs was they didn't have the equipment to be able to go ahead and get as good of a vacuum inside the bulb to be able to run the light bulb for extended periods of time. If you don't have a very good vacuum in the bulb, what'll happen is the air in that bulb will oxidize the metal, the filament that's in there, and cause it to burn out. So you want as good a vacuum as you possibly can have. So, what he was doing there is he had the ability to make a good vacuum, all right, but he was still running into problems with getting filaments that would last a long enough time so you weren't changing the bulb constantly. And what his invention for the light bulb was, he came up with a new filament. It started off being he tried thousands, literally thousands of different materials before he found a type of bamboo that was burned and it was charcoal. And then he was able to use that in the bulb for a long period of time so that they could get light. After that, they came up with a better idea, which was using tungsten. Tungsten was a metal that really wasn't discovered until around the time that Edison was working on the light bulb. And that was a metal that has a very high melting temperature and therefore was very useful to be in the electric light bulb. So here's a situation where he had an idea, he knew what he wanted to accomplish, and he tried a lot of different things before he came up with his invention, and he was entitled to a patent for that. Now, there are other ways you can have an invention. So, here's a very common product, and so it doesn't have to be very scientific to get a patent on something. Many years ago, a patent was granted on the ubiquitous paperclip, all right? And that was a very simple idea. And we used thousands of them. The patent has long since expired, but, that's something that was very simple and very common. Another important invention was something most of us use every day. It's called a zipper, okay? And, these are all simple ideas. So here's a patent that was issued in the 60s. And this was developed by a guy in France or Switzerland, I forget which, who went ahead, he was on a hike in the mountains and he had burrs. You know what burrs are from the plants that stick to your pants? And he's found this to be a pain in the neck, but it gave him an idea. Gave him the idea to see if he could use that idea of the burrs to come up with a fastening device. And this is something that you use a lot. It's called Velcro. And this is purely because he went ahead and he was paying attention to what was out there. And, he discovered this. It wasn't a big research project or anything like that. It was a simple idea that he, saw something in life and went ahead and used that to come up with an invention. Many of us have gotten penicillin, all right? Penicillin's another example of an invention that was not planned. It was not a lot of research and development. When Fleming came up with the idea, it was purely fortuitous. So for example, this is what happened in the late 20s. Fleming was working on some projects. He used what is known as agar, which is a nutrient, and he had it in a Petri dish. And he was going on vacation and he didn't clean up his office very well. And he goes on vacation for, 3 or 4 weeks, comes back and he says, oh, gee, all these agar dishes that I had with nutrients in it, they grew bacteria, but they're contaminated. And he started to throw them out, but he noticed something on them, that there was a mold in the dish. And around the dish, there was no bacteria growing. And that got him starting to think, so what is in that material that caused the mold, excuse me, caused the bacteria not to grow next to the mold? And from that, he came up with penicillin, because that's what his invention was. So, here's a situation where he's paying attention to what's going on around him. And that's, a way of inventing things. It's not just sitting out and saying, I'm going to come up with an idea to do this. Let's do this. That's fine. You could do that. That's Edison. He wanted to come up with a better light bulb. But a lot of times it's fortuitous. It's just being at the right place at the right time and recognizing that there's something going on that could be worthwhile to investigate. So here's another idea, all right, that became a product that probably all of us have somewhere in our house. It's a microwave. Well, in the microwave, there's a magnetron, which is a scientific device, and they were using it at Litton Industries because it's very useful in radar. So one of the scientists was standing by the magnetron when it was on, and he had a candy bar in his pocket. And the candy bar melted. He said, put 2 and 2 together. Let's go ahead and see what we can do with that. And that's how they came up with the microwave, because they realized that heat was being generated by the vibrations of the ions in the chocolate. And he came up with this idea, and that's how Litton got involved in the microwave. Another fortuitous type of invention. How many of us have used these? Post-it notes, okay? On the back of the Post-it notes, there's a glue. So 3M is going ahead and they have a project to come up with a new glue. They tried different formulations, and one of them came out, it was a good glue. It held. Problem was it never dried. So it really wasn't that good for sealing things or anything like that. Finally, somebody got the idea at 3M, maybe we could use this as a notepad. And that's how the Post-it note was developed. It's an idea that somebody saw and took it and ran with it. So patents can cover a lot of different things. Patents can cover machines, they can cover products, they can cover processes, they can cover chemical compounds, a lot of different things. They're very difficult to go ahead and protect computer software these days if you're doing it and it's really just a method of doing business. But there's a lot of things that patents can protect. Here's another idea. It's a simple idea. You use it all the time. It goes back a long time, but somebody got the idea to make toilet paper and put perforations in there so you could rip it off. A clever idea. We use it to this day, 100 and some odd years later. Toys, you could protect toys. Now, if you look at this picture that we have here, this will give you some idea of the kind of detail that's needed in a patent application. So this is one figure from a Super Soaker gun, all right? And all of those numbers in there are parts of the gun that are described in the patent application. You'll have to describe, we would go ahead and talk about how each of the parts are linked together so that somebody can go ahead and read the patent and make the product. Now, the patent lasts for 20 years from the date of filing. And in order to go ahead and give you that patent, there's a quid pro quo. The government says, we will give you exclusive rights to prevent others from making, selling, or using your invention, but in return, you have to tell us your ideas. So hundreds of years ago, somebody would have a great idea, and he would never tell anybody. And so the idea would typically die with them. So when the United States, we came up with the patent system based on the English system, and it was based on inventions. And the idea was that when you give a patent out, we learn how to make something, and therefore the technology can be built on that. And that's one of the reasons why, we have so many patents out there, because they grow and they're all, building on something before. In the first 200 years of the country, we only had 4 million patents. Since then, since 1976, there's been 6 million more. So, there's been a tremendous difference in the growth of technology in these last, almost 50 years. So, and who knows what it's going to be for the future, but it's very valuable to have this body of knowledge that's available to people after the 20-year term is up, that they can go ahead and make, improvements of that. And also the patents go ahead and they're useful in developing alternative ideas. Let's say somebody had a similar idea for a super soaker type of gun, but he doesn't use the technology. That's another advantage. Somebody will try to design around it. Sometimes they can and sometimes they can't. So, that's the value of the patent system. Now, how do you get a patent? Well, there's an application process. So for most people, when they have an idea, you want to go ahead and try to protect it as quickly as you can. So there's a provisional patent application that gets filed, and it describes the invention, and you try to file that as quickly as possible, because whoever wins the race to the patent office gets the patent. That provisional application does not have to have all the details. It can just be drawings. It can be very simple. And it gives you, once you file that, a year to flesh out your invention. And people use that year to do more R&D work. They do it to go ahead and try to get investors. They use that year to try to sell the invention. As you approach the end of the year, you have to file the full regular application. And those applications can be, 10, 15, 20 or more pages long. This would be one of those figures that would be in there. You would have a number of other ones in there. For example, you might show the other side. You might show the top and bottom. You might show an exploded view. Once you file the application, at some point it'll be reviewed by the examiner, and he'll make a decision whether or not to grant the patent. If you don't agree with him, you can argue with him as to why he's mistaken. And typically what he does is he'll find a piece of prior art where he says, well, that's basically your idea with just some minor changes. And you will go ahead and argue with the examiner. Those changes are important. Nobody would have ever thought of that. And it goes back and forth with the examiner if he doesn't allow it on the first go round. Once you get a notice of allowance, the patent will issue. And as I said, it lasts for 20 years from the date of filing. I got to give you some idea of costs. The whole process from start to finish for getting a patent is not cheap. It's $15,000 to $20,000. Sometimes it's less if it's very simple, but for the most part, unless it's a very complex device, you're going to be in that $15,000 plus or minus range from start to finish. The application filing is cheaper, but you will have those other costs as time goes on. So here's another thing that you can get a patent on. You can get a patent on a new form of life. In this instance, they were not able to get a patent on the sheep, but they got it on the process of cloning the sheep. But I have seen patents on mice, and there they will go ahead and they'll change the genes a bit on that mouse to go ahead and have a mouse that has certain attributes that are very useful. In one instance, there was a patent out there on a mouse that where the genes were changed, and the mouse was very susceptible to cancer. Okay. And why would somebody be interested in a mouse that's susceptible to cancer? Well, cancer frequently takes a long time to grow. So it's difficult to tell whether or not a treatment is particularly effective, because the cancer may take a number of years to manifest itself and go ahead and cause problems to the living organism. So therefore, a mouse that showed cancer properties quickly could be very useful in testing different types of treatments.
Mm.
Okay. So, here's a patent. So patents are not always for things that, are really useful. But here's something that was granted in the 1890s, an automatic hat tipping device. I don't know whether he made any money on that, but, people do file patents on a lot of different things.
So Tom, so in the patent category, of course, that would be individuals. Oh, did we lose Tom?
I'm right here.
Oh, okay. It seems like in the patent category would be great for individuals who are very much interested in creating a design, right? That's going to be that group, right? In that group. But what about the markets of those who, for example, like the Malls Group, it's their website, their logo.
We'll get into that.
Okay.
Okay.
That's their main interest. So that's why I'm asking about.
So there are other things you can get patents for.
Mm-hmm.
Patents on plants, if they're asexually reproduced.
Mm.
Another area you can get a patent on is a design.
Mm.
You have a piece of furniture that you've designed, it's a chair, let's say, and it has a back and legs and everything like that. If it's very artistic, you can get a design patent on that, which will last 15 years.
Mm-hmm.
Here's an example of an Apple iPhone. They have a design patent on that. And you'll see companies, file for designs on a lot of different things. Maybe a high-end piece of furniture, maybe a fender on a car to prevent knockoffs from, making similar products. So you can get a patent on a design, and they're much less expensive than a regular patent. But you have to recognize that people have to buy the product for the design, not the function. If you're going to buy a product for the function, the regular patent is what you have to go for.
Mm.
Okay, so here's another design patent that goes back a long time, and this gets starting to get into an area that we're going to talk about now, which is trademarks.
Mm.
So this is a design patent that was granted in the 30s to Coca-Cola on the shape of its bottle. But in addition, they have trademarks on that shape of the bottle, okay? And that shape, if you see that shape, it's a Coca-Cola bottle, okay? So let's talk about trademarks. It's the name of your business, all right? Trademarks can be the name of the business, the name of a product. It can be a slogan. Coca-Cola, you may remember, was the pause that refreshes.
Mm-hmm.
Slogans are very commonly trademarked. And we'll talk about some other things that you can get trademarked on. But the key thing with a trademark is it's a badge. It's to show a source of origin, so that when you go to a McDonald's and you see the golden arches up in front, it tells you that there's a certain type of quality that you can expect there. And that's because they're using the trademark to tell people what kind of products are there.
Hold on a second. Okay.
Okay.
Yes. Mm-hmm.
So it's to tell people that what kind of product you're getting. So in the years ago, when you would drive and you'd go on vacation, you know, there were not a lot of franchise operations out there, and you never knew going into a restaurant whether the mom's restaurant was any good, what kind of food they have. But the advantage of a trademark is that it tells people that there's a certain amount of quality, may not be a high quality, but there's a certain quality that you can expect from going there. Okay. So what's a good trademark? All right. There are different types of trademarks. At one time, aspirin was a trademark. All right. The problem was it became generic because people used it the wrong way. People used it to describe the product. When you blow your nose, what are you using?
Tissue.
Ah,
Or
very
a
good.
hanky, or a hanky.
Kleenex
lot of
was the wrong
people-
answer.
Oh,
But a
Kleenex
lot
is
of
the wrong
people
answer?
say, they say Kleenex.
Oh,
And if you look at the package, it says Kleenex tissues.
mm,
When you have a boo-boo, what do you put on it?
Band-Aid.
Band-Aid.
Right. But it's a Band-Aid brand adhesive bandage. All right. So trademarks can be lost if the public associates the trademark with a product, a generic product. So when you go to make a photocopy, what are you making? You're making a Xerox copy.
Xerox, true.
And it doesn't matter whether it's on a Xerox machine, a Sharp, or whatever. And for years, Xerox would write letters to people and say, you can't use it that way. Okay. Now, there's, in the trademark area, there's a back and forth between the trademark lawyers and the marketing people. The marketing people want a trademark that tells you what the product is. It makes their job easier. Okay. The trademark lawyers want to have a unique trademark that people can't tell what it is because that makes it a strong trademark.
Wow.
Okay.
Can you give an example on that? I mean,
Of a strong trademark.
right, that they can't tell what it is. What, can you clear that up?
Okay.
with?
So let's take this trademark that's right in front of us here. Now, what is a Google? And we're talking about, you know, years ago. All right. Now, I only remember one time anything closely related to Google was out there. There was a gentleman on a PBS program that some of you may remember that had blue fur and he had round, googly eyes.
Hmm,
Cookie Monster.
cookie, oh, that's right.
Okay. That's the only time I ever remember hearing the word googly. Okay. So they came up with Google. It means absolutely nothing. And that's a very good trademark.
Hmm,
Another good trademark from years ago, they're no longer in the business, but it wasn't because of their trademark, but it was Kodak. It was a made-up name. It didn't mean anything to anybody. It's a great trademark, okay? But you have to advertise that a lot in order to get the public recognition. All right, here, now let's talk about another trademark. Let's say I wanted to go into the fruit business. Okay, I can't use the name Apple because it describes the product. It's not a trademark. It's not a badge. It doesn't tell people that my apples are any different or anything else over and above anybody else's apples. Okay, but let's say I had a different product and I was going to call it an apple. Okay, the computer has nothing to do with apples. All right, there's no cider in them. It doesn't have any, you know, fruit flavor or anything like that. You can have a name like that that's very useful because the public, you know, knows what apples are, but they don't know computers. And as time goes on, it becomes a very strong trademark.
Wow. Tom, I just want to say this. I think what you just said is so important. It cannot be reiterated enough. Because at times when I'm working with clients to help them to create a business name, they will fight me tooth and nail and say, but the name is not, I want a name that says what the business does.
Okay, and you know, that is a problem. They can live with it, but at the end of the day, when somebody else comes up with a similar name, then
Yeah,
you'll be able to stop them.
there you go.
Okay?
I'm just praying that everybody here is hearing that, okay? Because.
Okay, and that's the
Right.
key.
Yeah.
All right, if you use a descriptive name, okay, like Vest,
Mm-hmm.
it doesn't mean anything. It doesn't distinguish you from anybody else. Okay, so here's another one. Okay,
Mm-hmm.
Acme. All right, now the Wile E. Coyote, he's been a customer of Acme for years. You may remember from Roger Rabbit, it was Marvin Acme was the head of the company.
Mm-hmm. Mm-hmm.
All right. Acme is a very weak name, but there are people out there that use Acme trademark, and there's hundreds of them all over the place. It doesn't do them any good for picking that name.
Right.
Okay.
There is
So
a
when-
question, Tom, there's a question in the chat.
Okay.
There's a difference between trademark and brand. I think that's the question.
All right. They're one and the same.
Okay, there you go.
Okay.
There-
All right. When you have a brand,
Mhm.
your badge, it's your badge of origin. It's a trademark, whether it's your personal name, whether it's your company name, it's a trademark.
Mhm.
Okay. And, how do you acquire trademark rights? Well, there's a couple ways you can acquire trademark rights. The first way is through use. All right. The more you use a trademark, the more powerful it becomes. It starts off as being the name of your store or your business, and you may be in one geographical area. As time goes on, you may expand. All right. The more advertising and promotion you do, the stronger that trademark becomes. The other alternative way is to file for a trademark registration, which will give you nationwide rights. Now, what you need to do first is to do a search to find out who, if anybody, is using that name. And it doesn't mean the exact words, because I get people coming into me and they say, oh, we're different. We put a hyphen in there. And that means nothing, because what you have to understand is when you're looking at a trademark, the test is public be confused when they see this other product out there with a name that's similar.
Mhm.
The closer the wording is, the spelling and things like that, the more similar it is to the prior trademark, the harder it is going to be for you to say that you can use it and they can't stop you.
Wow.
Instance, if you have a very famous trademark like Tiffany, no matter what kind of business you're in, Tiffany's going to come after you. Okay. Let's say you want to use the name McDonald's. If your name is McDonald's, you better make sure, if you're going to be in the restaurant business, you make it clear that you have no connection with McDonald's. Not like McDowell's on Queens Boulevard, okay, where he had the golden arches with the M. You got to make sure you're completely different. So it may be Joe McDonald's Bar and Grill or Joe McDonald's Restaurant. That could be all right, but you have to be very careful. Okay,
Mhm.
have something famous out there. Now,
So Tom, wait a second. Is it okay for them to ask questions? I see that it's in the chat. Can you answer those that's in the chat? Or what's your recommendation?
Why don't we do, well, we can answer some questions. Where are they?
Hold on a second. Let me just try to mute somebody. Okay. Very good. So in the chat, we have,
Okay, all right, here we go, have some questions. Let me go back to the beginning and hit some of those questions.
okay.
Okay, somebody has a comment about Edison and Hollywood.
Hey, Wayne, is it okay if I say a few?
Oh,
things?
yes. Oh, Kyle is still here. Yes, Kyle would like to, he asked a question first because he had to go. So Kyle, yes, please answer.
Go ahead, Kyle.
Kyle.
Yeah, can you guys hear me okay?
Yes, we're hearing you slightly, but we're hearing you.
Okay, yeah,
We lost you.
Yeah, we lost him. Either you went on mute or something, we don't know. I know he's been falling off for a while. Kyle, if you're hearing us, we are not hearing you anymore. Okay, he may come back on, but you started to answer.
Okay, so yes, there's a comment here about Edison being notorious with his patents. Very true. He was very grasping with those patents. Anytime anybody did anything close to what he thought was his, he would go after him. He had a lot of backing from financiers to be able to do that. And there was a movie many years ago, I forget the name of it, which sort of told this story about the movie business moving out to California to get away from Edison and his patents. So, but that is true. Okay.
Mhm.
Velcro. I remember this story. It's kind of gross. What do you mean?
Sorry, I was just making comments while you were speaking about the penicillin, how basically they found it growing on someone's desk. That's kind of gross.
That's not the gross part of it. Okay, so let's talk about the gross part of penicillin. Okay. All right, it's during World War II. All right. Now, one of the things with penicillin is the prior antibacterial treatment that they had was called sulfa drugs. And that was very commonly used during World War I. So when somebody got a wound, okay, in order to prevent gangrene, they would take powder sulfa drugs and put it in the wound to prevent gangrene from growing so they wouldn't lose their arms or legs. All right. And if any of you seen the movie Gone with the Wind, where there's got the sawbucks sawing off arms and limbs, that was very common in those days to prevent gangrene. And the sulfa drug was really a miracle drug during World War I. So you get to World War II, and typically in the late 30s, they're trying to use penicillin. They recognize that it's very useful, but they're using it in the same way that they use sulfa drugs, meaning that we had a powder and they would put it in the wound. And that's not the best way. Penicillin doesn't work that way. So there was a big program to get more and more penicillin available. And it was a little company in Brooklyn that was very instrumental in commercializing penicillin. And that company was Pfizer. They were, a small drug company in Brooklyn, and they got a contract from the government to make penicillin. Penicillin was so rare when a soldier got wounded, and they finally realized that the way to treat penicillin was to give you a shot. All right. But penicillin was so rare that they went ahead and they collected the urine from the person who received the penicillin, and they would separate the urine from the penicillin so they could give it to somebody else. That's how much of a wonder drug it was, but they didn't have enough of it to save everybody at the time. But they were really ramped up, not unlike ramping up the COVID, vaccine. but they did a lot of work. But until they were able to ramp up production, that is what they had to do. So that's the disgusting part of Penicillin.
So Tom, what I'll do, I'm going to ask the questions so I can go through the main questions, and then at the end of some of these novelties, I'd like you then to discuss. Is that okay? Because I don't want to take you off track.
No, that's fine, because people have had questions. Let's answer them.
Yeah, so Ratasha is saying, Tom, if your name of the business is common, should you consider changing it?
You know, that's a very difficult question. It's better to start off with a right name right from the start, but if you already have a business, you already have goodwill developed. I think you just have to recognize that, you know, you may not be able to have as much growth in the business to other parts of the country if there are other people using a similar name. So what you may want to do is think about, if you're going to expand, perhaps expand under a different name or add something to it to make it, you know, distinguishable. All right, that's not uncommon because one of our biggest companies in the country, or it used to be, was Standard Oil of New Jersey. All right, and many years ago, the Rockefeller family owned all the oil companies, and the government made them split them up in the early 1900s. And everybody got the right to use SO as an abbreviation for Standard Oil. The problem was, you know, in the original days of motoring, you know, people didn't travel very far. There were no roads. But after the World War II and in the 50s, and they started building the interstate highways, you know, the gasoline companies wanted to expand to other parts of the country, and they couldn't under that name, Esso, all right? In New Jersey, there was Esso. In New York, there was Saucony, Standard Oil Company of New York, which became Mobil. You know, Dad would go ahead, he's taking the family down south to visit relatives. He's got his credit card from Esso, and he finds out the Esso down there is not Esso Standard Oil New Jersey, it's some other company that won't take the credit card. So going back to the late 60s, early 70s, Esso and Standard Oil New Jersey had enough of that, and they wanted to come up with a different name. Now, they had a lot of goodwill in the name Esso in the New York metropolitan area, so they wanted to come up with a name that was as close to Esso as possible so people wouldn't have trouble making that transition. Came up with Exxon. Okay. And if you want to know which companies were originally Standard Oil companies, as you travel, you can look at the red, white, and blue colors on the signs. If they're red, white, and blue, they were a former Standard Oil company. So you had Chevron, which is Standard Oil of California, Ohio, which was Standard Oil of Ohio. There was Standard Oil of Indiana, which became Amoco. You had Saucony, Standard Oil in New York, which was Mobil, and you had Standard Oil of New Jersey, which was Exxon. And there were probably another 25 or 30 other Standard Oil companies, but none of them had the marketability or the ability to expand that business like those companies did.
Wow, that's powerful. There is another question here. I think Ronnie had also asked it, where she actually said Google now became a verb, Google it.
Okay, so that's the problem for Google. What they're going to do is, when people go ahead and write in the newspaper, Google it, if they're concerned about that, they will write letters like was done with all, you know, with Xerox. And, you know, they'll write to the people who come up with dictionaries and things like that to correct it and say Google is a registered trademark. You'll have to use it the right way.
Wow.
And it would be, you can't say Google it. They'll want you to go ahead and say to do a Google search or to use the Google search engine. But it's not an uncommon problem for companies that, you know, have a lot of association with their names. Some of us, you know, if you're a coffee drinker and you like decaffeinated coffee, you may recall commercials years ago where they emphasized Sanka brand decaffeinated coffee. And that was because it was only one decaffeinated coffee at the time. And they didn't want Sanka to become the generic name for caffeinated coffee. Now everybody and his brother has decaffeinated coffee. And I don't even know if Sanka's still around, but it's not a problem anymore. And usually when it's not a problem anymore, a la Xerox or Sanka, you lost your market share and, you know, the value of the name has deteriorated.
Wow. That's a whole nother conversation for the marketing department.
Sometimes they do their job too well.
Oh, boy. I tell you, let's see if there's one more question. I don't know if Niger was making a comment or a question, but I thought I saw it somewhere. Is it helpful to get a DBA for your business until you can get a trademark?
Yes.
Really?
Okay. Yes, because you have to get a DBA because, and they're very simple and they're not very expensive. You do it at the county clerk's office or through New York State Secretary of State's office. It's basically a fill in the blank form. And in those instances, you know, you need to do it so people know who you are if they have a hold of you. So it is worthwhile to do it. It doesn't give you any rights outside of where you're using the name.
Mm.
The more important issue is the question of what about a domain name?
Mm.
Okay. So many times, you know, people will get the domain name first before they pick out the trademark name, because if they can't get the domain name with the .com, a lot of times they don't want it. So that's very important. And that typically becomes the first step. And my recommendation is, because domain names are not that expensive, it's really worthwhile to, you know, get, you know, if there's a bunch of names you're interested, get them if they're available right then and there, and don't take a chance that somebody else grabs them. And then you could go ahead, and once you have like 4 or 5 names, then you can decide which one you want to do from the trademark standpoint.
Wow.
Because the domain names, because they're so cheap, people grab them all the time.
Okay. Yeah. And then they charge you back for it.
Right. Now, you know, you have to recognize is that the domain name doesn't talk necessarily about the type of products you're selling. So unless you really have your heart set on a particular domain name, I'm not so sure I'd want to spend any real money trying to acquire that, because, you know, you could go add a -1 after the domain name. All right. You could add an additional name to it. You know, some of you will go ahead and you'll get correspondence from a firm in China sometimes saying, oh, we wanted to bring your attention that somebody was going to go and get your domain name.
Yes, we get a lot of that. Is that real?
No, it's not real. It's all a scam.
Oh, wow. Okay.
Scams out there like this. So you have to be very careful and just recognize that, you know, your name can be you go broke trying to protect all the different variations on your name. If you're a big company like McDonald's or Tiffany or somebody like that, or Crayola, you're going to do that. And you'll write them letters and say, you know, that's ours, get out of here.
Cease and desist.
Right. But, you know, you can't worry about those kind of things, because you're playing whack-a-mole. You know, as soon as you get rid of one, another one's going to pop up.
Now, Tom, one more thing I wanted to say here is that at times influencers, right? Actors, actresses, singers, they become popular because, like you said, they're using their name. But then those ambitious individuals would lock your name up. So we noticed a number of celebrities had no choice but to pay $30,000, $40,000 to reclaim their name from someone who was smart enough to know that their name is getting popular and they would lock that name up. And that actor and actress now would like to get back their name because they need to use it for intellectual property, such as clothing lines or something else, and they're forced
Okay.
to pay that kind of money. How does that work?
Well, about 25 years ago, that was a very common practice where I would go ahead and buy all these domain names for pennies and, then go to the company whose domain name, whose trademark it was, and say, we'll give you the domain name for $10,000, and they would try to hold them up. And that was, people were making money off of that. And I believe the company was Panavision.
Mm,
If you watch movies a lot, you'll see at the end of the movie, there's filmed in Panavision, which is they make the cameras.
I see.
And they said, we're not paying you. So they sued them for trademark infringement and they won. And that once they did that, all the other companies did the same thing. So they put a stop to that. All right. Now, it's a little different if you're going to be commenting on something. So let's say you want to comment on a famous actor or actress. All right. And you get a domain name that says, has the actress or actor's name in it, and you add other words and you're using it more for commentary, it's much more difficult for them to stop that. Just the way it's the same way, it'd be more difficult for a regular company to go ahead and stop you from, getting the domain name, Google stinks, okay? And you're using that for commentary as opposed to selling products or services. Unless you're selling products and services or disparaging a product, it's very difficult to falsely disparaging a product. Let me clarify that. It's very difficult to stop use of a trademark. You cut out, Winnie.
Okay. Okay, so that was, let's see, there's one, I think, Nisha Howard asked, I was going to say difference between trademark and patent. I guess that's a question. I don't know if it's a statement or comment, but I assume, it's a question that there's a difference between trademark and patent.
Yes, I mean, the only time you really have an overlap between the two is like the Coca-Cola bottle. You could get a design patent on the shape of the Coca-Cola bottle, and you get a trademark on that shape as well. All right.
Mhm.
But there are things that, there are other areas where there are overlap. You have trademark overlap in the copyright area as well. And we'll
Mhm.
do that. Were there any other questions you wanted to hit while we're here?
No, I think we are good. I mean, I know Thomas just chimed in that there was a law firm, Morgan, Lewis and Batchiers, that had to give up his domain name because a big client wanted it, Major League Baseball. So he had to give up his name.
Well, what was the domain name? If the domain name was Yankees, you're gonna have to give it up.
I can understand that.
All right. But I will say, Major League Baseball does do a lot of licensing. The problem
Yes.
is that, if you want to get a license from them, the terms are not unreasonable, but the minimums are. You have to
Mhm.
want to go ahead and you got to sell a lot of product to make it worthwhile.
Okay. All right. So let me let you continue, and we're going to answer some more questions at after this. Okay. So this was the break. So we'll let you continue, and then we're going to ask Sylvia. We see you here, but let him continue his presentation, and we're going to have the Q&A at the end. We just needed to take a break to answer the questions.
Okay.
Those who had
So
yes.
Here's Coca-Cola. You can get a trademark not just on the words, but you can get it on the stylized script as well.
Mm.
Coca-Cola has this unique stylized script. And what they did was, there was a company many years ago that used that script and was selling T-shirts that said cocaine.
Mm.
Okay. And Coca-Cola went after them and got an injunction and damages and put them out of business. But so
Wow.
the advantage of having the stylized script as part of your trademark repertoire, because it would cover those kind of instances.
Powerful.
Now, we talked about traditional trademarks, names and slogans and things like that. But there are other things that can be trademarked, all right? So how many of you have put this up in your attic?
Yes,
Installation, okay?
yes.
Now, about 30 years, now it's more than that, it's probably closer to 50 now. A company called Owens Corning went ahead and applied to get a trademark for the color pink. And the Patent and Trademark Office gave them a hard time and they had to fight it. And they showed that they did all this advertising and promotion of the color pink. They had a license with the movie The Pink Panther. They used the Pink Panther in their commercials. Pink is not a color that's natural for fiberglass. Fiberglass looks like that normally.
Hmm.
Was able to be something that could be trademarked
Mhm.
because they advertised it. They created goodwill in that and they created recognition in that. And now you may not have that kind of budget for that. The Patent and Trademark Office does give you a similar ability to do that. You can go ahead and you can get what's known as a supplemental trademark registration, which means that it'd be on a color, let's say, and you don't have the ability to go ahead and show this recognition, but you file it, you get your registration, and then after 5 years of continuously using the mark, you can go ahead and have that registration strengthened, and you could have a strong trademark in color.
Mm.
So there are other non-traditional trademarks that are out there. Here's a color for one. All right. Now, there was a big lawsuit involving these shoes and the trademark.
True.
And the end result of the trademark lawsuit was the trademark was limited to shoes that had the sole pink and only the sole pink. Because they were able to show that there were other shoes out there that were entirely pink. So the trademark was limited to the sole. If somebody sells a shoe where the sole is this reddish color, but the entire shoe is that color, that company can't stop you.
Mm. Interesting. So what about Louboutin? He has known as the red bottom shoe that every woman aspires to wear.
That's what that trademark is.
Ah, the red bottom shoe. Okay.
Red bottom shoe, yes.
Hmm. So no one else, I remember when they had that injunction in China, they had them at the airport and all those cases of knockoffs of the red bottom shoes,
Right.
they squandered. Okay.
So if you have a patent or you have a trademark, you can notify customs and they will stop those goods from coming into the country.
Wow.
It's, to be honest with you, it's not easy for them to catch it because there's so many different ports of entry that are possible.
Mhm.
It does help sometimes that they can catch it.
Mm, okay.
So here's another trademark, but this one's on the scent. All right. How many times when you were a kid, you'd smell that Play-Doh and that had a very particular scent to it? Well, they were able to get a trademark on that Odie scent that they have.
Mm.
Okay.
Interesting.
By the same token, they had to show, that people recognize that smell. And, the kinds of things that they would look for in those things to show that would be articles which, people talking about Play-Doh reference the smell. And that would enhance their ability to show that that was entitled to trademark protection. Now, here's a company that has a trademark on a strawberry scented toothbrush. All right. I guess it might help the kids brush their teeth, but it certainly would seem to me to be more like candy that maybe that would attract them to it, but they have a trademark on that scent.
Wow.
Sound can be a trademark. All right, you're sitting there watching your video one evening and this movie starts and you hear the roar of the lion. Well, that's
Yes.
the trademark. All right, you're watching Star Wars and that have that 20th Century Fox opening. That sound is a trademark. Okay?
Mm.
These are all things that can be trademarked because there are public recognition of these things as coming from a single source.
Mhm.
Lamborghini has a trademark on how their doors open. Okay? Now, patents have a specific term, 20 years. This helps Lamborghini. They could have this trademark forever as long as they can show that it has trademark significance, meaning that the public recognizes that as coming from a source.
Mm.
So trademarks have a term. They're typically 10 years, but you have to show use periodically. And, as long as you keep showing use, you can keep your trademark. If you stop
Interesting.
using the trademark, you can lose it.
Wow. It's good information.
Here's another shape.
Hershey.
Ah, you got it. All right. And,
Yes.
you say to yourself, well, how valuable is that? Well, there was an instance about a year or two ago around the holidays where a lot of chefs were complaining that the tips were breaking off. And they didn't want to use the Hershey Kiss on their culinary or confectionery concoctions. But they couldn't go to anybody else because Hershey had the exclusive rights to that design. So they had to live with the fact that the tips were breaking off. All right, now we're going to get into copyrights. And copyrights is very important for your website. Okay? Now, when you have your website built, you have to make sure that whoever is going to build the website, you get the rights to the copyright to that website. You need that in order to make changes to the website because under the copyright law, that computer programming is copyrightable. And the author is the only person who has the right to go ahead and make changes to that. And unless you are the owner of the copyright, you have no right to go ahead and make those changes. So let's say you get your web guy, he goes ahead and does the website, and then you're not happy with him, all right? He's not responsive. You needed to have it updated. You got a price change coming in there. You're adding new products. He's not responsive. You can't do that. You got to go ahead and make sure that you have the rights to do that, and then you'll be able to make those changes. So in any agreement that you have with your web designer, it has to be specific that you make it clear that you have the exclusive right to the web site and you have the copyrights. Most people say, well, I paid him, $5,000 or $6,000 and that therefore I have the rights. No, because just because you paid for something, all you get is a license to use it. You don't get copyright ownership in it unless it's specifically stated in writing in an agreement. So that's very important. The other thing you have to be very careful about with your website is where is the content coming from? The number of times over the years I've seen people come in and say, I got the cease and desist letter because we have a picture on the website. And, the web guy put it up there. I thought he was getting a license. And these guys pull this stuff off the web so easily, and then you're left holding the bag. And then, you get the cease and desist letter, they don't want to hear from you.
Mm.
So you need to have some control over and have them tell you or give you copies of the license that they have when they're showing a picture. And you say, well, they'll never find me. I'm a little guy. But
Mhm.
there are these spiders out there that will crawl through the web, finding these,
That's so.
and you're going to get nailed. And it's very expensive to fight it. You can't win because it is copyright infringement. And, the fact that you were innocent of it doesn't matter.
Mm.
These, and the web designer, good luck in trying to catch them.
Mhm.
So, make sure that if you're going to use a photo on there, you took it, or you're using something that is, royalty free, and make sure you keep the terms and conditions, that it is a stock photo that's available, or if you paid X dollars for it, maybe it's a nominal amount. Make sure you keep a record of that. So in case anything happens down the road, you have the ability to show where it came from. And that applies not just to pictures, but people want to use, sound or video on there as well. All of this stuff can be protected by a copyright. And it is very expensive if something comes up and you get a cease and desist letter. I've had a couple of instances where, it's a shame. I even have one instance where a photographer took a picture of somebody and that person used that picture on their website and then got a cease and desist letter from the photographer, even though it was a picture of themselves. So, be aware of that. It's a problem, and take steps to avoid any issues by knowing where the pictures or the material comes from.
Wow.
So what can be copyrighted? Well, software can be copyrighted. Now, you could also get a patent on software, but there is a distinction. A lot of the software guys say, oh, I'm only going to go get a copyright on the software because it's cheaper. The problem is there's a lot of different ways you can write the software and accomplish the same result. You have Word, you have WordPerfect. There's, a lot of different programs out there that are similar that give you the end result, but they don't encompass copyright infringement. That's where a patent would come in, because if you can get a patent on it, it would cover the functionality of the software as opposed to the code. The functionality is much more valuable to you because you would prevent somebody from achieving the same function, okay, no matter how the code was written if you had a patent. Okay. All right, what else can be copyrighted? Artwork. Now, this is an interesting situation here. This is Andy Warhol, okay? Famous artist, and he goes ahead and draws a picture of the Campbell's soup can. Now, does he have any trademark problems with this? Right? No, because he's not selling soup. Okay, he's selling artwork. He's making a commentary on that. So it's just artwork and there's no trademark infringement. Now, copyrights last a long time. All right. Copyrights are starting to expire now that were published in the early 20s.
Wow.
So, that's a long time. So, unless it's something from before 1920, you got to be very careful if you go ahead and use it, that you could run into a problem that there's still a copyright extant on it.
Mm.
Music can be copyrighted, right? And music is very interesting because you can get a number of copyrights on the music. You can get a copyright on the words. You can get a copyright on the music itself, the notes, and you can get a copyright on the performance. So all of these things can be protected. And so you will have a situation where if you were to go ahead and sing the songs that Julie Andrews singing here from the movie, all right, The Sound of Music, you would have a concern about using that music on your website because there would be a copyright on it. But you could get a license to use that. ASCAP and BMI do have licenses available. They're not cheap, but you could do that and you could use that music on your website. You could also go ahead and you could sing the song yourself and you would have a copyright in your performance of that song. You would still owe royalties to the owner of the song and the music, but you could have a copyright yourself in your performance. So that's why you see some of these musical groups will cover a song and they will have protection for that song that they're singing, but they still would have to pay a royalty to the author of those songs.
Interesting. Interesting.
Okay. And, the other issue is for copyright, because they last so long, the copyright laws have changed over the years. And sometimes, years ago, they lasted for 28 years and could be renewed for another 28 years. And, sometimes, people didn't go ahead and renew them and let them drop. But like, for example, some of you may recall that there was a time, probably in the late 70s or early 80s, where you couldn't turn on the TV around Christmas time and watch It's a Wonderful Life. What happened was that movie came out in the late 40s, the 28 years were up in the early 70s. At that point in time, there was, DVDs and VCRs were a dream and it didn't exist. So the owner of the copyright never went ahead and renewed the copyright registration. That's made it available for anybody to go ahead and show that movie on TV without having to pay for that. So that's why you saw it all the time. And then all of a sudden, around the early 90s, it disappeared. And the reason for that was, we talked a little bit about this before. Remember we talked about, only the owner of the copyright has the right to make changes to it?
Mm-hmm.
Well, the movie It's a Wonderful Life was based on a Christmas card that a gentleman wrote to his friends, the bare bones of the story, around 1943. And that copyright was kept in force. And because the movie was based on the Christmas card, they were able to resurrect the copyright in the early 90s. And so now you are only limited to being able to watch that a couple times each year whenever the rights owner gives the television programs the right to go ahead and show that movie.
Wow.
Okay. And that also explains a lot of times when you say to yourself, gee, I remember this movie when I was a kid. And I love that movie, but I can't find it anywhere. Why is that? You would think that they'd be out there and trying to make money off of it. Well, sometimes it's very loosey-goosey when they sign up these writers and authors and musicians and everything like that. And they're sloppy in getting the rights. So one prime example is the movie Fantasia. Fantasia came out in around 1940. But at the time, the music there was done by, I think it's Arturo Toscanini of the Philharmonic in Philadelphia, who was quite a name, all right? And somehow they were able to keep the rights to the music. So when Walt Disney wanted to come out with the Fantasia DVD or the VCR, they had to negotiate that with the Philharmonic in Philadelphia. And it took them a while. And that's why that movie went ahead and ended up being late in getting out to DVD and VCR. It probably didn't come out until around 1991. Up until that time, all those other Disney movies had been out there.
Mm.
So that's another reason why some of these movies that you like, somebody has the rights to the music, okay? And sometimes it's hard to find out who has the rights. Google had a project called the Gutenberg Project, where they were going ahead and they were digitizing all these old books that were out of print. And, you know, there was a group of authors that fought to stop them, and they wanted to go ahead and prevent Google from doing that. And Google said, well, you know, if somebody has the copyright, let them tell us and we'll take it out of the list, but let us make the digital copies of these out of print books so that they're available for the public. And the authors refused to do that. So there are a lot of books that are no longer available. Maybe a library had them at one time, but for space constraints or everything like that, it got the heave ho or it fell apart over time. And, you know, you would love to be able to read it again, but they're not available to you because of the issue with the copyright.
Wow.
The way the fight was, Google wanted to be protected from willful infringement, that it's sort of, the author had to opt out, all right, from doing this. And the authors fought that tooth and nail, and then finally Google said, forget it, we won't do it.
Wow.
But, you know, that's why certain things are the way they are in, you know, in some of the movies being available.
So Tom, can we answer some questions here for a moment?
Sure.
I guess this one is exactly what I see that you have there. The question was, how do you protect your intellectual property as a professional dancer, the dance moves?
Okay, so this is the Nutcracker here.
Mhm.
You may see different Nutcracker performances out there. The New York City Ballet puts on the George Balanchine version of the Nutcracker. And that is where the choreography is protected by copyright. George Balanchine did that. And, you know, if you want to see what that copyright looks like, it's basically dance steps and, you know, okay? And, or it could be just the video of the dance. So that is one way of protecting choreography. Some of you may remember a number of years ago, there was a Dust Devil commercial with Fred Astaire, okay? That was on, and they were advertising the Dust Devil, and he was dancing with the vacuum cleaner, okay? And it was a scene from one of his movies. Now, the work that was necessary to go ahead and get the rights to that, if the movie studio did not have all the rights, can be phenomenal. At a minimum, they were going to have to get the rights from Fred Astaire's estate. They would have to get the rights from the choreographer. They would have to get the rights for the music, both the notes, the words, and the performance, okay? So it's a complex process. They would also have to get the rights to the story. So, you know, it can be very complicated. And now at the end of movies, you see people getting a credit on there at the bottom, you know, amongst all the other names on the movies, where they have the licensing person who's got to get the rights to everything that's shown in there.
Mhm. Wonderful.
So
Okay.
that's dance, photos. Photos are a big problem for many people on their website. They want to use photos of different pictures, and all of these are protected. The more famous ones can be protected, but even less famous ones. I saw an instance where just a regular street scene was used by somebody. They could have gone ahead and taken the exact same picture of their building, but they didn't. They copied the picture and they ran into a problem.
Wow.
So, when you have your website done, make sure you know where everything comes from. All right. And then we have the interface between copyright and trademark. All right. So what you have here is the Poland Spring bottle, the label. You can have a trademark in the mountain scene, and you could also have a copyright in that mountain scene because it's artwork.
Mm.
So you could see, now, we're not talking about the words Poland Spring, that's clearly a trademark in and of itself. But we're talking about the artwork. The artwork can be both a copyrighted work and a trademark.
Gotcha. There was just one question more here. I had a domain name about 12 years ago, which I didn't keep up, and it was bought by someone. All of a sudden, I received an email if I'm interested to buy it back. What do you think I should do? Thanks. That's by Sylvia.
How important is that name to you?
That's the question. Yeah.
Right?
Mhm.
Is it that important? You lived 12 years without it.
Yeah.
If it is important to you, if it's a nice, catchy domain name, maybe it is, but how much are you asking for it? So these domain names can be worth, $5 to thousands of dollars. And, you have to really make a tough decision as to whether or not it really is worth it to you.
Mhm. Okay.
Are there alternatives that accomplish the same thing? Is the .net out there? Is the .us out there? What else is out there? Can you live with that? I can understand years ago, domain names were very important because, you hope that people would type in auto.com when they're looking for a car. But they don't do that. They use Google. They Google it, right?
Mhm.
Domain names are less and less important because the search engines have gotten so good, they're going to find what you're looking for anyway. So you really have to think long and hard if that is really valuable to you. It may not be, and that's a tough decision.
Mm. Okay.
All right. Now, the last area that we want to talk about today is trade secrets.
Okay.
Okay. Some people want to protect their IP by keeping it a trade secret instead of filing for a patent or securing a copyright. You actually can, if it is a computer program, get a copyright on a trade secret program. There are steps you can take with the Copyright Office to go ahead and file it in camera so that the entirety of the program is not revealed. But some
Mhm.
people want to keep it as a trade secret, and you have to understand trade secret can be very valuable, but you could lose it in a flash.
Mhm.
Tell what the product is, what the trade secret is from the product itself. Going the trade secret route is not going to help you. So if it's a mechanical feature, it's probably not going to be protectable as a trade secret, enough that will really make it worth your while. The only alternative you're going to have is to really go ahead and protect it by way of a patent. Now, Coca-Cola is a trade secret formula. And, I understand, but I can't be sure that nobody really knows the entirety of the formula. It's two people know parts of the formula, and It's put together, and what makes Coca-Cola. That being said, there's a lot of other colas out there. So, you can do a very sophisticated NMR or an IR and analyze the Coca-Cola soda. So you'd have a pretty good idea what's out there. But whether it tastes like Coca-Cola, it probably will not taste exactly the same. But you have to understand that, it's not going to prevent people from competing with you, because there's, Royal Crown Cola, there's Pepsi Cola, there's King Cullen Cola, there's, all different kinds of cola there. And, some people are Coca-Cola drinkers. Some people are Pepsi drinkers. Some people don't care. But, you have to take a look at and see whether or not trade secret is the way to go. The problem with trade secret is, you have to worry about your employees leaving and taking the secret with you. And, once it's out of the bag, it's out of the bag. And, there's very little you can, there's certain lawsuits you can bring, but it's tough it's like Pandora's box. Once everything is out, it's tough to put it back.
Very good. Let's see, there's one more question here. Hold on a second. I do want to ask a question. It has to do with a web designer asking for, okay, so he's giving a contract for the payment of the website, which you already stated that whatever he designs is, he has that, that.
Copyright.
But this is the first time I've heard of a designer asking for monthly royalties for the use of the site. Is that legal to ask for royalty?
Yes, he could do that.
Wow.
But whether or not you want to have a contract with him, when there are other people out there who will do the same thing, this guy would really have to be a really good web designer that's really going to have a lot of bells and whistles on there, that money. Now, it's one thing if he gives you a lesser price, because so this way he's spreading it out over time. That could be one thing. There's a lot of reasons why you might be willing to do that. You have to understand that at the end of the day, you could be paying a lot for that.
That's what I'm thinking, because number one, there's a difference between licensing and royalty, right? So royalty is that you're making money, but how would that designer know that you're making money to charge royalty? Isn't the royalty based on sales?
No, it would be just based on how much traffic you had to the site, because
Wow.
the designer's not going to want to have to dig into what your books are for him to tell how many people came to the site.
Right. That's
Now, he might be providing more services than just the website. He might be doing, he might be directing the traffic there. Okay. He might be setting it up so that the keywords will come out more often in Google searches, higher up in the search results. There may be things that he's offering, and that's why you may be worthwhile. Maybe there's keywords searches that's included in that price. You can buy keywords at Google.
Wow.
That might be something maybe that's part of what he's doing. You have to know exactly what the deal is.
Wow. Okay.
If it was just a website that, unless he's charging you a little each month, and, it's a way because you have limited finances to start off, it may not be worth it.
Okay. Yeah. So I'm glad that answered, because there's one person here who had that issue, but he stated that he told him no, he didn't go through with that at all.
And you have to be very careful in those agreements, because the web designers know what the rules are and they don't tell you what they are.
Wow. And then you get locked in. That's
right.
So when you get these contracts, it's wise to really give contracts to an attorney than try to interpret it yourself.
Right, particularly in the copyright area, because, it could be, there's a lot of aspects to the website depending on the type of business you're in. You know, you have the ability sometimes to take credit cards on there. You may want to have the details of who your customers are, who the traffic is coming to the website and things like that. You know, you want to have as much control and as much knowledge from the website as possible so you can adjust your business in response to this. If you're finding that certain things go ahead, or certain keywords or certain days of the week are busy days for web traffic to you, you might go ahead and use that information to tailor your website and your AdWords purchases to those particular times.
Mhm.
And that can be very valuable information. And, you know, you have to know what kind of work the web designer is going to be doing and what he's going to be telling you.
Got you. Another question, can I pay for a content from an author that is copyright free and then copyright that content to use on my website? I almost know the answer to that, but I'll let you answer it.
Okay, the answer is depends on what the terms and conditions are.
Mhm.
A lot of free material out there, okay? There can be pictures out there that are stock photos that anybody could use, but you have to read the terms and conditions to understand what the requirements are. Sometimes they may let you use a photo, but you have to give the photographer credit.
Mhm.
And that is, you know, the quid pro quo for going ahead and being able to use the picture for free. If you don't give them the credit, you could have no license and then be liable for copyright infringement.
Mhm.
So it's very important to read those terms and conditions. The thing is, you know, some of these stock photos say you can't use them for commercial use. Well, what does that mean? Does that mean a website? Depends on what it says in there.
Mhm.
That for your kid who's doing a project for school. You know, you can use that picture of Antarctica for the you know, the science project, but you can't use it on your website. The terms and conditions are the key to your use of anything on your website.
Wonderful. So I have one more question and then I'm going to open it up so others can just directly ask you the question themselves. One of it, I believe it was from, well, Sylvia did mention that Coca-Cola sodas in the Caribbean taste so much better than the ones in the USA. So the flavors in different countries, I guess.
No, what sometimes that is, they may use pure cane sugar as opposed to corn syrup.
Oh, okay.
See that some of the stores that cater to Mexican families, they have a different type of Coca-Cola available and it's made with cane sugar.
Wow.
So,
Okay.
you know, the way Coca-Cola is, there's the headquarters in Atlanta, but there are bottling companies around the country and around the world. Now, Coca-Cola in Atlanta owns some of those bottling companies, and they've made an effort over the years to get those back, but there are still some independents around there, out there.
Mhm.
Thank you
Gotcha.
so much. Thank you, Winnie. I find that with 7-Up, Fanta, I don't know, when I travel to the Caribbean, including my parents, is the sodas, the waters, you know, it's just seltzer waters and it just tastes much better. You know, it's just more, I don't know, it's a more real cola, I guess real soda taste. I don't know.
Yeah, well, you know, there was, back in the olden days, there was a movie called Smokey and the Bandit. I don't know if any of you have ever seen that movie. But the whole tenor of that movie was bringing Coors beer from Colorado to someplace down south. I don't know whether it was Georgia or someplace like that. At the time, Coors had restrictions on where their beer could be sold because they contended that if it wasn't sold and kept at a certain temperature for a certain, you know, for at least a certain period of time, I'm not sure of the details, but it wasn't, it deteriorated. So they placed restrictions on the ability for many people to buy Coors beer outside of Colorado. And that's what that movie was all about with Burt Reynolds and I forget Sally Fields. But that whole thing was about bringing a truckload of Coors beer. And so there are differences in the beers, there are differences in the sodas, the difference in bagels and pizza, depending on where you are eating them.
Yeah, makes sense. Okay, Ronnie had a statement about archiving. Ronnie, could you answer that, please?
Sure. So, your story about the Guggenheim project with Google reminded me about this website called Internet Archive. And basically, they have a program where people will donate their books. They'll donate scans of their books, and then they'll let people check out those books digitally. But one of the things that I noticed that they do is only one person or maybe two people can check out a book at a time. So what does that mean when it comes to patents and not patents, but copyrights and licensing?
The license controls everything.
Mhm.
When you go ahead and you put your DVD on at home and it says licensed for home use only, you can only use that DVD, you can only use that book for certain restricted purposes. Because all you have is when you buy a DVD, when you buy a book, you just receive the hard copy of the book. You do not receive the copyright. So you can't go ahead and change the ending of the book. You can't, make a movie out of the book. There's a lot of different things that you cannot do. And it's part of that basket of rights that, the author is giving you that they can place restrictions on that. You see a lot of this, I don't know if any of you are teachers or work in the school system, but, the kids want to put on a play and, depending on the play, there are different rights involved. And so, you really have to, you go ahead and you really have to buy the play from the company that licenses it out, because even though you might have a book that has all the words in there, you could run into a problem because you don't have the right to put on the performance. And that's, sort of like what you're talking about. The author is placing restrictions, which they're entitled to do.
Mhm.
And does that cover derivative works? So let's say someone does a parody of Mary Poppins or something like.
Okay, now the parodies are a different thing. There is the concept in copyright law of fair use. Now, you may notice tonight we used a lot of copyrighted pictures here, but it's fair use because I'm not using it for commercial purposes. I'm using it for educational purposes to teach people about copyrights. So
Mhm.
fair use. There's no commercial, I'm not getting a commercial benefit from the use of that copyright. I am not going ahead and hurting somebody's revenue stream by using that picture.
Right.
Parody is like that. You're not hurting somebody's royalties for the songs from A Sound of Music. You are commenting on certain aspects of that show or certain aspects of the song, which you're entitled to do. Now, if your comment is very minor and you're playing the whole song, but the comment is only a minor portion of that, you might be in a difficult position to say it's really fair use because you may be going ahead and using such a part of the copyrighted work that you've appropriated it in its entirety.
Got it. Thank you.
I just have two more and then we can wrap up unless anybody else want to raise their hand to speak. One was on if it's okay to, I believe, I don't know if it's Ronnie who asked, but somebody asked the question regarding sometimes you see on the internet, on Facebook, or Instagram, they will be playing music to maybe a party or something, and in the top, it will say, I don't have the rights to this music. Is that sufficient coverage?
No,
And that's very popular. Everybody is using that comment.
right. And,
Rights to that
you know,
music.
they don't seem to be going after that as much as they otherwise would. There
Mhm.
seems to be a lot of music on the internet that if they wanted to shut down, they probably could very easily. But they don't, they were more concerned about their income stream from downloading the songs than from these things on YouTube.
Mm.
Change tomorrow. Sometimes you'll see all of a sudden a thing that you thought was there is gone. And that
Mhm.
typically is that
Somebody
somebody
just
came
caught
after.
up to it, yeah.
Yeah.
So they're getting away with it just for that moment, but knowing that it's not.
Yeah, I know there was one about a year or two ago where I think it was a woman on a plane who had the baby doing some kind of dance to a song. And there was a big to-do about that. And I think at the end of the day, I think they reached some kind of resolution. You know, it's the same way too. You know, ASCAP, the American Society for Artists and Composers and Producers, as American Society of Composers, Artists, and Producers, is very, very grasping when it comes to rights. There was a time in the early 90s when I went after the Girl Scouts for singing their songs around the campfire. And, you know, the public was up in arms about that. They thought that was outrageous. But at the end of the day, I noticed that the Girl Scouts did take a license. I don't know what the terms were. I don't know whether it cost them anything. A lot of times ASCAP doesn't want the publicity and will give them a sweetheart deal so they can go ahead and say to somebody else, some other group, well, the Girl Scouts took a license, so it could be of value to them. But, you know, they will come after people and try to go ahead and get you to pay a license if you're going to do that. It's the same way too when you go to a venue. If you're a band, you know, if you're going to play songs at that venue, either you or the venue has to have a license. And, you know, you better make sure you know what that is before you start playing. Because, you know, they have, just like Coca-Cola has people going around looking for instances where the restaurant goes ahead and serves you Pepsi when you ask for Coke. You know, there are ASCAP and BMI send people out to go and see if music is being played and they're not getting their royalties on it.
Yeah.
And one other area that you should be aware. You go into a diner, you go into a restaurant, and they got a radio playing in the back room. Better make sure that they got a license or they turn the radio off.
Oh, there you go. Those jukeboxes back in the day.
Well, the jukeboxes were all right because they were licensed.
Right.
Chef's got his radio blasted in the back and the patrons can hear it. He needs a license.
So what about the restaurants? So you're telling me the restaurants who have television or let's say the regular music they're playing into the restaurant for the clients, that needs to be licensed because it's in the restaurant.
Yes.
Wow.
So let's, you know, there was a guy,
That's deep.
you know, one of these bar and grills, I forget where it was a few years ago, where he had Cablevision, okay, for his home, which was above the bar. And he ran the wire down from upstairs down to the bar, and he was showing the baseball games or the football games in there. There are two levels of subscriptions to a lot of these cable companies. There's the home subscription
Yes.
and there's the business subscription. And,
Yeah.
you know, when they come after you, you're not paying the difference between the home subscription and the business subscription. They're charging you what it would be if you didn't have a license at all, and you know you were infringing, which can be very significant.
Wow. So in other words, if you had the business subscription, you still have to pay for the use of music coming from that or no?
No, it depends on what your subscription says. If your subscription
Okay,
is, let's say Cablevision is in, a spectrum at your business and you have the ability to show the football games or whatever,
Okay.
that's fine.
oh, okay,
You can go ahead and do that.
got you,
Any channel that's on there, typically you would be able to do, except
got you.
they have a separate pay-per-view thing that we wouldn't have access to unless you signed up for it. But I would make sure if I did sign up for one of those fights,
Mhm.
or that I knew exactly what the restrictions were before I, started,
Have your party.
yeah.
Winnie, can I ask a question, please?
Yes,
What about
yes, Natasha.
Macy's? Macy's play music that make us want to spend our money. Popular music is played in Macy's.
Yeah, well, they,
License.
that's like, they have music playing in elevators. They have a license to do that.
Do that. yes.
Really? Wow.
Yeah, they have a subscription for that, yes.
Yeah,
Just like when you have Spotify or, some of the other songs, you got to pay extra for that or you get commercial. It's a revenue stream and that
Yeah.
you're paying for that either in listening to the commercial or you're paying for a subscription. And Macy's is the same way. They wouldn't be able to play that unless they were going ahead and paying
they'll
someone.
be sued, yeah. All major companies will always have a license. And this last one, recipes. Ronnie had a question on recipes. Ronnie, and then we have to close.
Sure. So one of my clients, I was reporting her recipes for her, and we were discussing ways of protecting those recipes. So what are some ways to protect like recipes for restaurants?
Recipes are not really protectable.
Mm-hmm.
Okay. Yes, you can go ahead and you could write the recipe down and you could have it in a book form or a booklet form. And if somebody copies that recipe, and starts to publish it, you may have an argument that there's copyright infringement. But most of the people change the recipe around a little bit and, it's tough to go ahead and show that. Now, there's an old trick that can be done in some of this stuff when you have a similar situation to the recipes. Let's say it's a very lengthy recipe, okay?
Mm-hmm.
You could do what the map makers used to do. A map is basically a paper, two-dimensional rendition of something that exists in the real world.
Mm-hmm.
Okay. And theoretically, if somebody had a map of Midtown Manhattan, how would you know that that map wasn't copied from somebody else's? So what they used to do in the olden days was they would put streets that didn't exist in there. They would put towns that didn't exist in there. Okay, so then you'd have the witness on the stand and he'd say, I did this map myself. I went out and I studied everything. And then they would be asked the question, well, what about this street here? Where is that? Did you go down that street? Or did you go to this town here? And then they would bring out the fact that those places didn't exist. And that's how they knew. And, that may be something that you can do, but it's, the recipe for the Toll House cookies in every bag of, chocolate morsels. So it's, and you probably we thought my mother had some, recipe from, that was in the family for generations, okay?
Mm-hmm.
And once in the Pillsbury book. So, they're there and, it's tough to, to protect those. And, those type of recipes, you can't get patents on them that are worth anything. Food concoctions, dog food recipes and things like that are very difficult to protect.
Very good. All right.
You know, she'd be better off becoming well-known as a chef as opposed to writing.
Excellent, excellent.
Thank you.
So we at the top of the hour, but we have one person who was on and had a problem. That was Kyle. Kyle, if you're on, you can ask the question and then we have to close. Get answered and closed. Kyle Griffith.
Okay, can you guys see me okay?
Yeah.
Yes, we
see
can.
you.
Okay, perfect. I don't know, Tom, I was going for like 5 minutes there. I think I could have copyrighted my edification of you, man. I was going on for a little bit. I didn't know what I lost my audio, but I just want to give a quick testimonial for Tom. Tom was very instrumental in helping me with my trademarks. I mean, it was him and his team over there were fabulous. He actually helped me change the name of my company, my brand, to help better protect my company and what we were building with the M&A network. So, you know, if you're considering, if you have clients that need assistance with intellectual property, you know, Tom is very well. He's gave some great presentations with M&A and here with malls. So, Tom, hey, great stuff. Sorry, I got kicked off earlier, but I did want to jump on and you know, show some love and appreciation for what you've done for me and my company. So thanks again.
Thank you, Kyle. One other thing I want to add, you know, if any of you have any questions that we didn't touch upon, you know, feel free to ask them. You know, I'll be happy to take questions, you know, in the next.
Tom, could you go to your next slide? Does your next slide have your contact information on it? If not, everyone could take a screenshot, use your phone and take a screenshot of Tom's contact information, his phone number and his email address. I must also testify, Tom has helped me out as well. And I appreciate you, Tom, in sharing with me what I need to do with my logo, you know, and that was awesome. He's a good soul, good guy, you know.
So, you know, you're gonna have
And Tom
questions,
Farrell.
and I'd love, you know, I'm happy to answer them.
Yes, yes. Okay. So that being said, Tom, I tell you, this indeed has been a blessing in the chat. I've seen some gratitudes being given to you, thanking you so much. Great information and the like. I just want to let everyone know that this video will be available tomorrow morning on the mall's Facebook page. So, you know, anytime you can go onto the mall's Facebook page, you can play the videos over and over there. That's where you'll be able to see it. And this is very good information. And there is also that email address. Tom is inviting anyone who would like a handout. Is that what it is, Tom? That if they need.
Yeah, I have a handout. I have the PowerPoint presentation, but of more value would be the handout, which is text and goes into a little more detail than.
Yes.
PowerPoint was more pictures than anything else.
Yes. And so for the handout, you can email him and he would gladly
Be
send.
happy to send it to you.
Yes. And that being said, I want to thank our audience for hanging in there, asking and participating in this valuable session here. And Tom, we are eternally grateful on behalf of Malls. Myself, we're eternally grateful for this rich conversation that you've had with us, and hoping that it has opened our eyes to see the possibilities and to abstain from getting cease and desist letters from now on.
Well, it's been my pleasure. I'm glad you found it interesting.
Yes, it did. Okay. So you could stop sharing for a minute so everybody could say bye. They can see each other and they can say bye. There you go, everyone. So now we could see each person, gallery view, and we all could can we all give a round of applause for, there
Thank you.
go. Thank you so very much. Thank you.
I'm so sorry. I know my Q&A was responded. My other cell phone died on me on my way home, so I'm coming from a job site. So sorry about that. But yes, I look forward to hearing it tomorrow.
Okay.
And I'd be happy to answer any questions that you had that weren't answered.
Yes.
Thank you so much.
Guys, all right. Thank you, guys.
Thank
and
you.
Have a great
Take care
week.
and keep cool.
Bye-bye now, everyone. And don't
Good
forget
evening,
the 20
everyone.
Good night. And
Good
don't
night.
22nd is how you're going to learn about your 3%. Okay, that's the next upcoming. On the 22nd, your 3% loan with 12 months deferred payment. Don't miss that one. It's Thursday the 22nd, okay? And
Okay.
good night, everyone.
Good
Goodbye.
Good
night.
night.
Good night.